We take it for granted that law is made and enforced by the state. Criminals are arrested by police, tried in state court and punished by the state. How could it be otherwise? Well, how could it be otherwise? One striking example is Icelandic law during the saga period. Murder was considered a civil matter, public property didn't exist, seats in the parliament could be transferred and even sold. Unlike today, conflicts were arbitrated by private courts, and law enforcement too was entirely private. How did that come about? Harald Fairhair unified Norway under one king, conveniently himself, in 872. Many of the early Icelandic settlers were small lords and kings from Norway who were fleeing his tyranny. Much like the early American settlers, the Icelanders were a rebellious and individualistic bunch, and so decided not to form any central government for their new country. Instead, they relied on local chieftains called the Goðar to regulate their domains. The settlers of Iceland divided the country into 4 regions, and each region had 9 chieftaincies. The lawmaking body, the Lugretta, assembled once a year in an open field. It was made up of the Goðar. The right to be a chieftain, a Goði, could be given away, inherited, sold, and even be held by a partnership. As David Friedman, economist and son of Milton Friedman, but let's not mention that, points out, seats in the parliament were quite literally for sale. Icelanders were required to name their Goði, but they could choose any of the Goðar in their quarter and change Goði at will. For this service, they had to pay a thing tax, which was negotiated in an entirely private contract. This, as far as we know, ensured competition between the Goðar. Icelanders could change legal systems without moving. Chieftains only had power if they could convince people to follow them, without the use of coercion. There was no one king of Iceland. Instead, the customer was king. The laws were applied by a system of courts. At the lowest level were private courts. Its members were chosen only after a conflict arose, half by the plaintiff, half by the defendant. When a case couldn't be settled, it went to the Farthing. As a general rule, there could be at most 6 dissenting votes out of 36, else the case went to the next level. Above them was the Fifth Court, appropriately named the Fifth Court. Only it reached its decision by majority vote. So, that's how Icelandic feud law worked. But didn't you forget about the executive? Well, yes, I did. But so did the Icelanders. In saga period Iceland, there existed no executive as we know it today. It appears that the assigned punishment was almost always a fine. Only if the fine wasn't paid, the defendant could be declared an outlaw by the court. The killer of an outlaw could not himself be prosecuted, and anyone who helped an outlaw could be prosecuted for doing so. For less serious offences, the penalty was lesser outlawry. Lesser outlaws had the right to leave Iceland and return after 3 years. But in short, law enforcement was entirely up to the victims. Wow, this must have sucked for the poor and weak. It probably didn't. In the Icelandic system, the right to be reimbursed by the criminal was transferable. The victim could sell it to the highest bidder or let his Goði enforce it to get justice.
So in that sense, I like to argue that modern American law is a mere 1,000 years behind the cutting edge of legal technology.
So, how well did the Icelandic system work? One could argue that it eventually failed in 1262. However, considering that it lasted for 290 years, which today would make it older than all but only a handful of the 200 or so countries, it probably didn't work too badly. While the sagas portray some pretty violent events, They were certainly a bit clickbaity, but that, I've been told, is just how storytelling works. What's interesting, however, is that in the sagas almost every casualty is personally named, and when attackers burn down houses, women, children and servants are usually offered an opportunity to leave. In one instance, a woman is abducted with the intention of marrying her. She's returned when she refuses. Compared to the violence of medieval Europe, this all seems very tame. Professor Einar Olafur Svensson estimated that the homicide rate was around 9.6 per 100,000. Much lower than medieval Europe's, and only about as high as America's in the 70s. Feud and violence, it appears, are not synonymous. But could the Icelandic system produce efficient laws? Perhaps. Suppose the wergeld, the blood money for killing a man, is too low. Sure, in a political system, one could in theory vote to increase the wergeld. On the other hand, as David Friedman argues, an efficient solution could also be reached in the Icelandic system. If some change in the law produces net benefits, one could buy up a number of chieftaincies, legislate the change, and come out ahead of the competition. Granted, this is limited by transaction costs, which in a medieval society are presumably quite high. But then again, this also applies to a political system. How well these systems work under given circumstances is, however, an empirical question. The relevant point is that there is no reason to rule out in principle that the Icelandic system worked. And, from what we know, and as strange as it may seem to us, it probably didn't work too badly. Thanks for watching. Please like to appease our algorithmic gods. If you're fascinated by the idea of eternal virtual torture, you're a bit weird, aren't you? But you are going to like the video I have planned for Halloween. It should be out in about a week. Subscribe so you don't miss out.